Hi, my name is Dan Shara from Miller Johnson's Education Practice Group. Today, for our 5-minute message, I'd like to speak about First Amendment protections for school district employees. Especially over the past few weeks, district employees have been finding themselves under fire for comments they make on social media relating to current events. Lately, it's been reactions to the murder of Charlie Kirk, but it's also other things too, whether it's Gaza, vaccines, opinions on law enforcement. There's been no shortage of things for people to opine on, and seemingly no shortage of people opining. When we look to see if an employee's speech is protected by the First Amendment, we look for three things. First, is the employee speaking on a matter of public concern? That is the topic of political, social, or community concern? Second, is the employee speaking as a citizen or as an employee? For example, is the employee posting on social media or talking to kids in a classroom or students at an assembly? Basically, is the individual speaking as a private citizen or are they speaking on behalf of the school? So there's a difference if we're talking about a personal Facebook post or comparing that to, let's say, a class newsletter or something like that. And third, we weigh the interest of the employee to speak on a matter against the interest of the district to perform its operations. So how much does the employee have a right to speak about something compared to the district's interest in efficiently operating its program? That is often the trickiest part of the First Amendment protection analysis. So here are some examples. We'll assume for all of these, we're talking about a teacher's personal Facebook post or a TikTok account. First, commenting on Jimmy Kimmel's take on the president or the president's take on Jimmy Kimmel. That's pretty clearly a matter of public concern, and unless the commentary was truly unhinged, it's going to be hard to say that that impacts the district's ability to perform its operations efficiently, and the speech is likely protected. Second, what if someone's commenting about Michigan versus Michigan State? Commenting on your favorite team is hardly a matter of public concern in the free speech context, so it's likely unprotected speech that we're talking about. If the comments were about players kneeling during the national anthem, though, then we're likely talking about protected speech, and we'd have to do the weighing of interests analysis to see whether that speech ultimately gets the protection from the First Amendment or not. Also, if a staff member is making profane or inappropriate remarks about a rival team, they're unlikely to benefit from First Amendment protections because just simply saying that something offensive about another team is not going to garner First Amendment protections. A third example is about an employee complaining about their job. If they're just venting or gossiping, that's likely not protected free speech, and they can be asked to stop doing that. If it's about a recent bond issue or a bond's impact on staff or student safety, and the employee is commenting on that, that is likely protected speech and subject to the weighing of interests analysis. So it really depends on the specifics of what someone is saying. Finally, what if a teacher puts up a post saying that ketchup belongs on a hot dog? A court is unlikely to find that to be a matter of public concern. So a post about hot dog condiments would likely not be protected free speech. That isn't to say a teacher can't share opinions on things like hot dog condiments. It's just that such opinions will not garner First Amendment protection. So if you want to talk to them about their post about hot dog condiments, feel free to. Something else to consider when doing this analysis is what position the person holds in the district. If we're talking about someone acting in their role as a citizen who is speaking on a matter of public concern, the weighing of their right to engage in the speech compared to the district's interest in operating a school can come down to what position in the district that person has. So the First Amendment offers more protection to folks who have less authority in the district. As we get to higher level administrators, their shared opinions are more likely to impact the district's ability to function, and therefore the First Amendment is likely to offer them less cover with regards to them expressing their views. So a janitor, a teacher, and a superintendent all saying the exact same thing can expect different results from the balancing test that is applied to their speech. Needless to say, this area is full of landmines. Should you wish to talk about a particular fact pattern, please feel free to give us or your counsel a call.